Hello, everybody, and welcome to A Place of Grace, our daily last edition. Well, today we're going to be talking about matrimonial regimes and contracts, because when we get married, we kind of forget that that is just the love aspect of it, and then there's also the contracts part of it that makes the marriage legal. So I invited a friend of mine, Ndweleni, to help us understand the different types of contracts and how we should handle ourselves when we get into marriages. Well, Ndweleni, welcome to my show.
Thank you, Mavhungu.
You must just take it as though you're advising me, an outsider who wants to get married, so that I best understand how to choose a contract that works for me best. I've often heard people a matrimonial regime contract, but I don't understand the difference. Or is a matrimonial regime one thing and a contract one thing? What are they talking about in that instance?
When people get married, there are three regimes that govern the relations in the marriage with regards to assets, debts, and things like that.
Okay.
So the Matrimonial Property Act provides for three regimes: a marriage in community of property, a marriage out of community of property with the application of the accrual system, and a marriage out of community of property without application of the matrimonial property
English.
act.
English is the one that dribbles. And then we end up choosing the wrong stuff. When we're talking about in community of property, what is that?
Well, when people get married in community of property, this refers to their estate. Once you are married in community of property, your estate, your respective estates, the husband and the wife, they become a joint estate, which is one. So it means that if I, as the husband, were to go out and buy a car, that car, as well as the debt that comes along with the car, if I'm buying it with an installment sale agreement, is mine as well as my wife's.
Okay, simply put, in community of property, changa di changa. Whatever I do under my name, automatically belongs to you as well.
Yes.
And then what is the other one?
There are two more. It is a marriage out of community of property without application of the accrual system. So if I can explain it better, haponduri changani changa, chaundi chau.
All right.
Yeah. Jambana zuri hapoi mwana muba kulima ndima yawe.
Okay. Well, we'll get into how we decide on signing those. And then the other one?
The third one is a marriage out of community of property with application of the accrual system. This one is a bit technical.
Okay. But in that, with the accrual system, is it, we are starting, because I'm picking up from the streets, we are starting, it's all mine, and then when we start, we can then, what I started with belongs to me, and then what we gather in the marriage, we can share. Is that even a right explanation?
To a certain extent, but it is not as simple as that. When you enter into an antenuptial contract, as you referred to earlier, it governs how the estate must be divided in case of divorce. So with accrual, each party is required, in terms of the act which I referred to earlier, to declare the commencement values of their estate, and then they also have the option to exclude certain properties.
Okay.
Yeah. So it is not per se that when we go forward after we've been married with the application of accrual, it does not mean per se that we are building an estate together. The one who accrues a smaller accrual at the end of the marriage has a claim against the one who accrues the bigger accrual.
Oh, because I thought when we're talking about accrual, like we can agree on the stuff that I'm saying we can share in, and the stuff that I don't want you to share in.
No, so if you want to give your spouse something, you would have to donate.
Okay.
a formal donation to your spouse.
Yeah.
So accrual does not work in assets, and it does not work in it does not work in transferable rights. So when you have a claim for accrual against the other spouse, it is not a claim for a specific thing. It is a claim for money.
Oh, okay.
Yes.
Right.
So they would evaluate the whole estate, then they would calculate accrual according to how accrual must be calculated in terms of the act. Then the claim is a claim in money, not in assets.
Okay, but can the richer one claim from the poorer one?
No.
Okay. So
No.
the beneficiary here is
Yes.
the one with less.
Yes.
Okay, good.
Yes.
Okay, but I've often, when do we sign these contracts that
Okay. So when before people get married, they must decide whether out of the three, which one they are going to enter into. So if you decide that you're going to be married out of community of property, whether with accrual or not, you must sign the contract before a notary public.
What is that?
It's an attorney of the High Court that has written a special exam. So you are admitted. In order for you to be a notary public, you have to be an attorney first.
I'm thinking.
Yes.
Okay, all right.
Yeah.
All right.
So I'm a notary public.
Okay.
So a scenario is if A and B were going to get married, and they wanted to get married out of community of property, they would come to me, we consult, and then they tell me what they decide. We draft the contract. They must sign it before they get married.
Why isn't it important that they sign it before the actual wedding day?
It is provided for in the Act.
Okay. All right.
Everything is regulated by the Matrimonial Property Act when it comes to this. So it must be signed before they go and get married. There must be 2 witnesses and before a notary. Then it must be registered within 3 months from signature.
And that can be past the wedding date?
Yes.
Okay.
So this means that we can sign it today and get married later today at 5 o'clock, and then it must be registered within 3 months from today. If the contract is not registered, it applies between the two of us. It is binding between the two of us, but not to creditors.
Oh.
In order for it to be applicable to creditors, it must be registered within 3 months at the deeds office.
So, but when you say it's not applicable to the creditors, is it you and I going to get into a negotiation of sharing if you want certain things from me? What is it about?
When I say it does not apply to creditors, I mean that for all intents and purposes, when creditors look at you, you guys will be married in community of property.
Oh,
but
okay.
Between the two of you, if you were to divorce with your partner, for all intents and purposes, you would be married out of community of property, as long as the terms of your contract do not prejudice creditors.
Oh, okay. I've often heard on the social media when people like marrying in traditional ways, we don't usually go and do the signatures that you're talking about. What happens when we follow the traditional way of getting married? What regime do we fall in, and how does that get regulated?
So when people get married according to customary law, in South Africa we have many different kind of customs. So what happens is that if you conclude a valid marriage without signing a contract to say you are getting married out of community of property, you are automatically married in community of property. So if, let's say, people decide that today we are going to negotiate lobola, and according to the customs of those specific people, the fact that you're negotiating lobola does not mean that you are married. Certain things have to be observed in order for them to be considered married. They still have the option to sign the contract until the correct procedures are observed in order for them to be considered married.
Do these procedures differ from culture to culture, or the law puts a blank criteria?
It is a case-by-case scenario, depending on what people practice according to their custom.
Okay, I understand.
And as well as the intentions of the parties. Usually when people get married according to customary law, certain things are recorded. The terms, they just don't know that they're doing that. But whatever they are recording there are the intentions of the parties. And if you look at that, and as well as the practices of the parties, you can determine whether these people are married or not.
Okay, let's say in a case where I stay with my partner and we then go and pay lobola in full. We've not done the ceremony and then we decide to part ways.
Yes.
Is that a divorce case, or families can just sit because we had just paid lobola, we had not celebrated, had not been welcomed in that other family?
It will depend on, as I said, it will depend on the customs and practices of the specific people. You might find that I usually say, put a test to it to say, if in those circumstances the husband were to die, or let's say if the wife, supposedly as she is called, were to die, where would she be buried? Would there be further requirements by her family required from the husband for him to do certain things in order for him to be allowed to bury her? So in those circumstances, you can see that these people are not married.
No matter what, if they make me sit on the mattress, you know how black people are.
That would be.
You know, they can make me sit on the mattress and then claim time. I'm not the wife.
Yeah, that would be your choice. And as I'm saying, it depends on the practice of and customs of certain people. So if me as the husband dies, and you as the supposed wife is required to sit on the mattress, that means that they regard you as the wife. It is all about intentions and practices.
So tell me here, do you recommend that when people in those circumstances where they've not done formalities, cultural formalities, when they're deciding to part ways, do you think it's important that they involve lawyers, or it's sufficient for families to sit and take minutes?
I think you must, first of all, you must go and speak with the elders that negotiated the lobola to establish the intentions as well as what was recorded in the agreement. And then if you feel that you are not protected per se, I think it would be advisable to go and consult an attorney.
Okay, because I've heard of ladies that are saying that they were married, like lobola was paid, functions were there, like it was like the normal mukiti, they've been welcomed, and they stayed with the husband as husband and wife. And then they decided to divorce at some point. Then they just sat as a family, two families, and agreed on the divorce. Is that divorce legal? Does it stand? Or
No.
That person can come back years later and still claim my assets?
The person can come back and claim. What we advise people usually is that if you and your partner agree and you've observed all protocols in that you would be considered married, all divorces are passed by a decree of divorce. If you do not have a court order stating that you are divorced, then you are not divorced for all intents and purposes.
Okay, so it means that if we don't follow that procedure and we just separated, it is a mere separation. It is not a divorce.
Yes, if let's say if the other spouse were to go and maybe get married again, the other party has a clear grounds in law to go and declare the subsequent marriage invalid.
Yeah, guys, the among your divorce.
Yes,
it's tough out here.
It is worth it.
And then, okay, when we are young and we are starting off in marriage, you find that choosing in community is the easiest thing to do. And we are forgetting that maybe we've got business aspirations And midway, we realize, hey, this contract is exposing us to a lot of risk as a family. When we want to change from one contract to the other, what is it allowed and what is the procedure?
It is possible. The first thing that you have to do is go and consult an attorney and make sure that the attorney understands the process. Then thereafter, upon consultation, you will bring an application to the High Court. So change of matrimonial regime, whether it is from out of community to in community or from in community to out of community, should be done by court order. So what would happen is that you would make the application to court, and then you would advertise as required so that your creditors are aware.
When we talk about advertise, is it on a newspaper?
Yes. You advertise on a newspaper, the government gazette. You notify.
Is for the creditors?
Yes.
Okay.
You notify the creditors. You notify your bank. If you owe your bank, you notify the master of the High Court. You notify SARS, the most important player in the game. And then thereafter, after you have observed all those protocols, you will bring your application to court. Whatever party has an interest in your matter will give an opinion. If they think that the change as you are applying for will not be good for business, let me put it like that, they have a right to object. If no one objects, the court will give an order as to how that must happen. So after that, you will go to a notary public. You will sign what is called a post-nuptial contract. This is no longer an ante-nuptial contract. The parties in the contract are described as married in community of property or married out of community of property. And then thereafter, the contract will be registered at
when you're reading things on social networks, people say that you have to divorce first to change into another regime. Is that what happens?
That is also an option, but it is not advisable because you can get into a lot of trouble with your creditors, especially if they are able to establish that your divorce was done for the purposes of changing your matrimonial regime, and that change as let me say, prejudiced their interest. Yes. Okay. So although the court cannot force you to still get married, the consequences financially, it can happen that the court orders that you put the creditors in a state that they were in before you got the divorce.
Hey, help me here. You men sometimes find that you're wealthier than the wife. When we are coming in as clients to consult, you can find that I, the less wealthier person, I'm struggling to articulate my terms inside that contract. How then do you advise your clients to, or you can't even participate, I don't know, you'll tell me, to strike, for me, the less wealthier person, to have a voice and be protected at the end of the day? Because you could find that because I don't want to give you the impression that I'm after your money, but I must also be safe when we are doing these contracts. How do you then advise clients where the levels in their financial exposures are different, way too different?
Usually when people are not agreeable to the same terms with regards to contracts, you would advise the one of the parties to go and seek independent legal advice, so that she can get someone who can he or she, let me say, can get someone who can negotiate the terms which are suitable to them. But in order for parties to cater for one another, it is permissible to enter, when you put in the terms of the contract, you can make certain stipulations to say, if we reach a certain milestone in the marriage, the husband, if he's in a position to do so financially, must donate a certain amount
Okay.
to the wife.
All right.
But
But do you advise in those things, or you just keep quiet and leave it to them?
No, usually when I consult with people, I usually tell the other people. It happens often that they are not on the same page. You advise them that maybe one of you should go and seek independent legal advice, and we negotiate the terms going forward. You understand what I mean? But when entering into a contract, especially an antenuptial contract, I usually tell parties that they must not just enter donation terms in a contract, because you cannot change it.
Oh.
Yes, you cannot change.
We can.
Yes.
But what if we agree, like we are agreeing that donation clause out?
It will be on principle. The clause will still be enforceable in court. So if you want to change the terms of an antenuptial contract, it is done by court order.
Sure.
Which is expensive as well. Yeah.
Okay. And then, in a marriage, things that just don't go the way we planned. In the event where we are married in community of property, and my spouse goes and has an extra marital affair where there's a child, in the event that they pass away, does that woman or that man and the child, which is usually the woman and the child, do they have a claim against my husband's share?
In the circumstances that you are married
in community of property.
So what happens, I'm not a deceased estate lawyer, but from the elementary information knowledge that I have, when people are married in community of property, they have one joint estate. So what would happen is that when the estate is being administered, first the woman would have a claim to a 50% of the entire joint estate. Then what is left to be administered is the remaining 50%, which was due to the husband. So if the husband dies with a will, then the benefits of his estate or assets will be administered in accordance with that will, whether or not there is a child or another woman or whoever. If he says that his assets must be given to charity, no one stands to benefit. So if there is no will, there is what we call the Interstate Succession Act. That act governs how the estate must be administered in case there is no will. So the surviving spouse, which is the wife, and the children, if there is enough in the estate, will share. Not
the mother of those children.
No. The child has a claim, not the wife. But obviously the mother has an interest to assist her child in claiming from the estate. Yes.
But now you spoke about a will. What is the relationship between the matrimonial, I don't know if when I say matrimonial regime or contract, I'm using the right terminology, a will and pension funding? Which one takes precedence? What is happening with those three things?
Usually, again, I'm not a pension fund lawyer. Usually, when a person dies, I leave a will. Pensions do not usually form part of a person's estate. They are administered by the trustees according to the beneficiaries that the deceased has elected, or according to the needs of the dependents. So that will be up to the trustees and how they govern that specific pension fund or annuity. And if anyone wants to challenge the way they have administered it, you have a right to go to court. With wills, the terms of the testator, that is the person that has signed the will, are absolute, unless if they are set aside by the court.
Wait, but the will can't override like when we're married in community of property, he can't say, I can't get anything. We are married in community of property.
Oh, well, there are certain instances where a person can be excluded from receiving a benefit from a joint estate. Let's say maybe if you kill your husband,
Yes.
you can be excluded.
No, okay, well, we've not proved
Yes,
that I killed. Wait,
yes.
we've not proved
So
that I killed my husband. But he just said, I agree, he knows me, the little creature he's living with. He's like, she mustn't get Jack. Is
Yes.
that possible? We are married in community of property.
It is possible, but only insofar as it relates to his 50%.
Oh, his 50%.
You will be entitled to yours unless you are excluded from getting the 50% because someone can prove that you did something.
You really did something.
Yes,
okay,
yes.
all right. You know, things happen in this life. We've heard of people that were married to person A and then jiggy, how? They're also married to person B. Is that possible in South Africa without me, person A, maybe getting divorced first or authorizing the second marriage?
Well, we touched on this aspect earlier. Ne? So, if in customary law, if two people are married and the wife, or since these days there's going to be polyandry, or the wife or the husband says to the husband, honey, I would like to take a second husband. In law, the husband, in terms of customary law in South Africa, the husband must consent to a subsequent marriage. But if you are married according to civil law, as we call it, it is not possible.
So,
yes. So, if you were to get married again, obviously Home Affairs has the right channels to pick up that this person is married. It would not be possible.
But you know, we've heard of, you know, Twitter streets and the Facebook. We've heard of people saying that when you stay with a boyfriend or a partner for, I don't know if it's 6 months or a year, like you are entitled to some level of claim. Is that even true?
It is what we call cohabitation. It depends. It goes with a case by case, and 6 months is hardly enough. Usually those cases involve people who have lived together for more than 10 years. And it is something which must be, if there is no agreement between or amongst all the parties that are involved, must be ventilated in court. So it will be a case by case situation that the courts can decide on if there is no agreement. Remember, the high courts in South Africa have jurisdiction to deal with any sort of matter that you bring before them.
Well, in closing, you know, when you want to finally divorce and then the other spouse is just running pillar to post, come go to Cairo. How do you divorce a person who is not coming to the party? They're not signing the papers. How does that procedure work in that instance?
In the courts, it is not just with divorce only. Ne? Musi mutu achiko shava, and they are not interested in participating in the divorce proceedings. You bring what is called a divorce by default. Yeah. So what happens is that if the person cannot be found, you advertise in the newspaper.
What?
Yes.
It's now a tender.
But you must bring an application first.
Okay.
The court will allow you to advertise by newspaper. You have to establish with the court that this person cannot be found. The last place that we know over Ahab is this place. Then we go to a newspaper that circulates within that place.
Guys, no.
Advertisement.
Guys,
and then after that, after service has been complied with in the newspaper, you bring an application by default, and then they give you your divorce.
Oh,
Yes.
but it's quite a funny process. Well, if people want to use your service, because I'm thinking we met nicely, suddenly now we must advertise it, and
If you're running away, reduce it to animal.
so we're advertising for him to be found, or for him to identify himself, or
We're
what is the purpose?
advertising for him to give him a chance to participate if he wishes
Because we're
to.
struggling to get hold of
Yes,
the partner.
yes. It's like people that have been married to our brothers.
Yeah.
Ne?
Yes,
or people that have been married to someone that is not from the country. You've married a foreign person, and you are struggling to find that person.
Yes.
Ne? You can approach the court to go and get a court order to serve them by what we called a dictal citation. So you will go and find a newspaper wherever that person comes from. Yes.
So
And
there's
then,
no person who can get divorced.
no,
Whether
no.
you're rata you don't want, or you shall be divorced.
Yes, as long as you establish to the court that I've taken reasonable steps and I cannot find this person. The place where I know the last time I was in contact with this person, the place where I know over ahab, ne? If we advertise, someone somewhere, whether it's him or a person that is close to him, might see the advertisement. Then you get your divorce.
Okay, just before we close, there are people that are not financially strong, or they don't afford legal services. How when we are following a divorce process, when I want to do it without involving lawyers, is it possible to do it like that when I'm married in community of property, as well as when I'm married out of community of property?
It is possible. You can approach, you can go to the courts. They will help you draft a summons. The only difficulty you will encounter if you're married out of community of property, and there are technical issues in laws that must be stipulated in your summons, you will have a problem. So I would advise people there is legal aid. Some people don't believe in it, but they are competent. People get divorced represented by legal aid all the time. It is just that they have a lot of work, and resources are scarce. If you don't prefer legal aid, you can go to the law society. Right now it is called the Legal Practice Council. Okay. What the Legal Practice Council does is that they see if you fit their criteria, and then they will give you an attorney in a specific field that will assist you pro bono without charging you. Okay. Maybe that attorney will only charge you for expenses which relate to running your file, like paying the sheriff, things like that.
Okay. And in closing, if people want to use your service, how do they get hold of you?
You can get hold of me on 071 4898 239.
Okay.
Yes.
And you're in Pretoria?
I'm in Pretoria, in the CBD at Corner Church and Andres. The new street name is Tabosi Home and Helen Joseph, 5th floor, Bank Towers.
Thank you so much. We learned, and I'm quite sure our guests also, our viewers also enjoyed the show.
Thank you for having me.
Thank you. I hope you guys enjoyed the show, and when you need legal advice and you're not sure about certain things concerning your marital contracts, you're more than welcome to contact Ndweleni. I hope you guys enjoyed, and I'll see you next time. Bye.